Hello, what's your name, please?
Sean Crosby.
Okay, Mr. Crosby, so you have two files here today, a new domestic violence charge, State of Michigan versus Sean Crosby, 222-0263, and then a older felony case, State of Michigan versus Crosby, 22FB1186. And you're here on that one because the new domestic violence is allegedly a violation of the bond conditions in your felony. Mr. Stringer, are you handling both files?
Yes, Your Honor.
Okay, go ahead when you're ready, please.
Your Honor, I got a phone call from Department of Corrections this morning, and I don't really know much about the case. So normally I'd waive reading of the information on that, but could you?
You want me to read the new charge?
Yes.
Okay. The new charge is a one-count misdemeanor domestic violence case. The complaint states that on or about May 31st, 2022 in the city of Ypsilanti, Washtenaw County, Michigan, defendant is accused of committing the crime of domestic violence by making an assault or an assault and battery upon Aisha Henderson, an individual with whom he has a child in common. Maximum penalty is 93 days in jail and or a $500 bond.
Again, I know very little about this. So we'd be just scheduling this for pretrial, that complaint?
Yes, it's an in-person pretrial with Judge Tabby. I think the bigger issue is going to be the bond on the felonies, so we should probably talk about that, and then we can figure out what kind of a bond to set on the other one. It looks like Mr. Danner would like to speak to bond. Would you like him to go before you, Mr. Stringer?
Well, we might as well see where Mr. Danner's coming from.
Okay, Mr. Danner, when you're ready, go ahead.
Yes, Your Honor, specifically starting with we did submit a bond form in regards to the domestic violence offense, but I want to start with the felony offense, which is the violation.
Mhm.
Your Honor, basically the violation is admitted to by the defendant. The police report is clear that he admits to the violation, admits to the contact, even admits that a tussle ensued. So it's no question as to whether or not he violated his conditions of release on his felony aggravated stalking case.
Mhm.
Problem is that since January 31st, when he was served with the PPO, which is the underlying event that made the stalking allegations from February, aggravated stalking, was that he had already been served with the PPO. The PPO had already been entered in the court, and I have that PPO number.
So should we be doing a PPO violation today too?
I mean, it is a violation of his PPO as well, because the PPO is active. He has an active PPO.
Okay.
He has active conditional release on the aggravated stalking. And then we have a domestic violence. So we have PPO, stalking, then violence. That is the exact level of how things increase to create a substantial danger to the victim, in this case, Aisha Henderson. In this matter, this attack occurred in front of a minor child while now, granted, the minor was a baby, so it's not as if the baby can necessarily recall what occurred, but it's the fact that the actions would occur in front of a child at the time when this individual is on several different court conditions that are supposed to reform his conduct and clearly have not reformed his conduct. So in this matter, for when it comes to this violation of his felony stalking matter, we're asking that his bond be revoked and he be remanded, or in the alternative that the court set a bond of $25,000, cash assurity, no 10%, as he's shown that he's a clear danger to the public.
Okay, so we're checking to see about the PPO violation, because if that's something that I need to arraign him on, we should handle that today, of course, also, so he can get that scheduled for tomorrow with, is the PPO in lien? I don't know. I don't have his, oh, I do have his criminal history.
Yeah,
Let's see.
22-169 PP.
Okay, thank you. So we're gonna checking on that to see if somebody wants us to do something so we can schedule any alleged violation tomorrow in front of Judge Vandenberg. Yes, it is in lien. And the policy of this court at this time, which Mr. Stringer, it's possible you're not aware of, it's a relatively new change, but the policy is that if a person violates bond conditions in a felony, then I am instructed to hold the person without bond until they can get in front of Judge Simpson.
Again, I know very little about the facts other than apparently the alleged victim came over to his place of residence.
No, I think that's true, but that's because he was contacting her.
Okay, well, I don't know that, but okay.
That's how it looks from the copies of the text messages that have been attached.
And just for the record, there was an offer, which is on the record, of a misdemeanor on this felony. And
Okay.
that matter is going to the preliminary exam or going to be resolved before June 28th, which is when that is scheduled. So, and I've had negotiations, I believe that might be with Ms. Londi. I think so. I think Mr. Danner would know. And so that's what's going on in that matter. I guess what's going to have to do with it he's a full-time employee, but it sounds like you have no discretion in doing this.
I don't.
And I don't know when we'd be going in front of Vandenberg.
Vandenberg, we can schedule tomorrow. We need to do the magic words on the record for that one, so we're getting together on that. But since he's still going to be in custody, we can schedule both the DV and the felony, the DV misdemeanor and the felony for Thursday the 9th, because the jail will be able to get him where he's supposed to be for Zoom. If the other option is for me to set a bond that perhaps he could post on the misdemeanor, so that depending on what happens with Judge Simpson, he could then try to post bond and see Judge Tabby the next week.
So Judge Simpson would be the felony, and of course I'm the
Judge Simpson
attorney.
is the felony.
Yeah.
And I truthfully, because, we're not in each other's courtrooms and I have a docket when he does, I don't know what he does in a situation like this, whether he will keep him with the bond, with no bond. I don't know. So do you want me to schedule both of them for Thursday the 9th and notify everybody that he's in custody?
That's fine.
Judge
Tabby.
Tabby's handling the new misdemeanor.
All right, but we'd go in front of Simpson on that?
No, you go in front of Simpson on the felony violation.
On the 9th.
Yes,
And we're scheduling also the misdemeanor
on the 9th.
in front of Tabby.
Correct. Let's talk about bond on that. So usually, given this particular situation, it makes sense to set a bond for your client so he can get some credit on the new misdemeanor, since he's going to be in jail at least a week.
Right.
And I think given the, as Mr. Danner has pointed out, repeated violations of court orders, whether or not the alleged victim, Ms. Henderson, is initiating the contact, Mr. Crosby knows not to engage and continues to do so. And it's not clear to me whether he started it or she did. So it appears to me that he initiated the contact, but I could be wrong. In any event, I think, as Mr. Danner has pointed out, it's a repeated violation of court orders. Additionally, repeated assaultive behavior. So a financial bond is appropriate for that matter for those reasons as well. So on the misdemeanor,
I'm representing him on several matters. Obviously, the court knows that, including custody parenting time issues that, and in all honesty, the claimant has been continually reaching out to him. Now, again, I don't know these facts. I don't know. He's charged with assault and battery, but and supposedly admitted it on a police report, but I have none of that information available to me. So I wouldn't want him to say anything on the
I have the
record.
police report
Okay.
because that's what when there's an alleged violation, I can see it. That's why I said I could see the emails.
Emails from my client.
or texts, I should say, yes, back and forth, multiple pages.
Okay. All right. And so just to set a bond, I believe on the misdemeanor makes some sense. Again, he has a full-time job. He's always appeared for every hearing. I mean, I recognize these are bad facts at the moment, but I'd ask the court to at least set some bond that he could possibly meet. I mean, I know he can't get out anyway at the moment.
Right. So I'm going to set the bond on the misdemeanor at 10,000 cash or surety. Let's back up on all of this stuff. Okay. As for the felony, 22 FB 1186, bond is denied per court policy. All previous conditions continue, including no contact. Mr. Crosby, maybe you don't know what that means. I don't know if I arranged you before. I did, so you do know what it means.
I didn't know what it means.
When she reaches out to you, you may not reply. If you reply, it violates your bond.
I understand, Your Honor. It's just
If
our
she
daughter.
comes to your house, you know what? So what? You're making a choice to put yourself in jail and to assault the mother of your child and to violate bond conditions on 2 court things because you want to see a baby who doesn't even know whether or not she's seeing you. That's selfish and immature. So it's a bad excuse. Don't use it as an excuse anymore. If you want to be a father to your child, grow up and follow court orders. I'm sure Mr. Stringer has given you a speech similar to this, probably in a nicer tone of voice because you're paying him, but
I object to that, Your
I'm
Honor.
not playing. Oh, you're not using a nice tone of voice with him? Okay. Don't screw this up. Every choice you're making says that you're a bad dad, okay?
I understand that, but I'm
No,
not
you don't.
accept what you're saying.
You don't understand it, or we wouldn't even be having this conversation. But maybe now you'll think differently about it because you're going to have a week in jail to think about it.
Yes,
A
ma'am.
minimum of a week in jail. Okay, felony, no bond, court date is June 9th, 9 a.m. approximately. That will be over Zoom because Mr. Crosby's in custody, and I think the show causes are still over Zoom anyway. All previous conditions continue. Do not reply if she contacts you. All right, any questions on the felony? On the misdemeanor, bond is set at $10,000 cash or surety. The pretrial will be over Zoom at 11 a.m., also on June 9th. With Judge Tabby. We've confirmed with his office that it'll be 11 a.m., so you should be able to see Judge Simpson and Judge Tabby both that morning. And the conditions on your misdemeanor are as follows. No contact with Aisha Henderson. No contact includes reaching out to her by phone, text, email, regular mail, walking by her house, going to where she works, going to her house, having another person speak to her on your behalf, using social media or FaceTime or Snapchat or Zoom or House Party or any other kind of face-to-face communication application or social media platform to have contact with her. You should not be going specifically to in Ypsilanti. If she tries to reach you, you should not reply. If she comes to your house, don't open the door. If you need to see your baby, wait until your cases are over. Any questions about the no contact order?
No.
On the PPO, we received a notice dated May 17th, 2022, that there was contact made. This is from Ms. Henderson's lawyer sent to the court, that there was contact between Ms. Henderson and Mr. Crosby at a gas station on May 11th, where he spoke directly to her at a gas station where they both were. And then, of course, we have this police report from yesterday where they had contact and he admitted to having contact. I'm denying bond on the PPO violation. Also, we'll schedule the court date with Judge Vandenberg for tomorrow afternoon, June 2nd at 1 o'clock, 1:30 p.m. That will be over Zoom. I'm repeating again, no contact with Aisha Henderson, including replying if she contacts you, including if you're both at the gas station, get back in your damn car and leave. Anything else on these matters?
No, Your Honor, I think we've covered it.
Okay, I don't want to see you again, Mr. Crosby, and you don't want to see me again.